California Attorney General's Office has 10 main divisions, which are identified in the white paper, but very quickly are the Division of Criminal Law, Division of Civil Law, Division of Public Rights, Division of Law Enforcement, Division of Gambling Control, California Justice Information Services Division, Division of Legal Support and Technology, Division of Firearms, Executive Division, and the Administrative Service Division. In the area of consumer protection and it is in the area of consumer protection and antitrust that the Attorney General has become most proactive in pursuing enforcement actions, damages actions, antitrust review, and in settlement of civil litigation. Although in the context of the more traditional role and powers of the Attorney General, the pursuit of consumer protection and antitrust actions is but a small part of the overall duties and responsibilities. However, it is here that critics contend that the modern State Attorney General often expends a disproportionate amount of energy and resources in this area. Today, this area of litigation also generates the most comment and controversy. While the role of the Attorney General varies from state to state, California serves as a good example of the historic role and function of the Chief Legal Officer and of other jurisdictions. As we will discuss in California and elsewhere, the traditional role began to change in the 1990s and continues to evolve into what we call the modern role. In the mid-1990s, state attorney generals added to their traditional role a function which has been called regulation through litigation, whereby state attorney generals bring state-sponsored litigation designed to achieve regulatory or policy-making objectives. The traditional role of the state attorney generals as the state's chief law enforcement official was uncontroversial. However, in the modern role, the state attorney generals do not limit themselves to their prescribed executive function. Instead, to the extent they pursue regulation through litigation, critics assert that they sometimes engage in legislative and policy-making activities more properly undertaken by the legislative bodies. A quick look at recent news sources includes the following stories of various state attorney generals filing lawsuits against a myriad of businesses and industries. In a series of cases, state attorney generals took coordinated enforcement action against multinational pharmaceutical companies alleging they broke antitrust laws to prevent consumers' access to cheaper generic drugs. In another action, California sued 6 of the world's largest automakers over global warming, charging that greenhouse gases from their vehicles have caused billions of dollars in damages. The former New York Attorney General uncovered numerous fraudulent deeds and practices, including illegal market timing and excessive fees by mutual fund companies. 9 state attorney generals filed a lawsuit challenging the Environmental Protection Agency's new mercury pollution standards. The suit asserted that the new rule fails to protect the public and children from toxic emissions from coal-fired power plants. And former New York Governor and former New York Attorney General Eliot Spitzer sued an internet spyware company alleging that the firm surreptitiously installed millions of pop-up ad programs on consumers' computers. In California, former California Attorney General Bill Lorie filed a $10 million lawsuit contending that a firm unlawfully obtained and sold wireless customers confidential monthly call records. So these are the type of actions that have become somewhat controversial. The tobacco litigation in particular has been the subject of much criticism and will be discussed further, I'm sure, by other speakers on this panel. Whether one approves or rejects the modern role of the state attorney general, it is clear that this changed role is here to stay. Since most states have elected officials to serve as attorney general, and like California, New York, and other jurisdictions, the state attorney generals are likely to continue to run for re-election or other political offices, a case can be made to voters that the use of regulation through litigation can be a beneficial means to an end without the usual red tape of government. It is also seen as a way for financially strapped states to raise revenues without raising taxes. However, it is important to be aware that in so doing, state attorney generals risk assuming the policy-setting function of an entirely distinct branch of government, in addition to other concerns which will be discussed throughout this program.
Thank you, Bob. I'm going to ask a question of Peter. Actually, I'm going to throw a curve at you.
Sure.
You guys are going to get used to that. Instead of one question, I'm going to ask 2. One question you know about. It says most state attorney generals are directly elected to their office. Is that relevant to this discussion? But let me ask you a second question that kind of, I think, goes in with this. Bob has just described a situation where we have regulation through litigation. And it bypasses all that red tape of government. I was under the impression that part of that red tape are appearances in front of committee hearings, administrative review where there's public comment. There's all kinds of opportunities for people to have input into the process. As a matter of fact, in Federalist 13, it was James Madison who wrote about the need to have slow down government and get the people have an opportunity to participate and be heard. Do we have an ethics issue there, or a question of the proper role of the Attorney General, elected or non-elected, in bypassing all of this so-called red tape?
Mm-hmm. Well, I think that's a very interesting proposition. I think how one views that issue really sort of depends on what part of which end of the political spectrum you're on. Liberals look at an activist attorney general, someone like Eliot Spitzer, the now former governor of New York, for example, and applaud the actions, most of the cases that he brought. Conservatives, while they certainly wouldn't be very happy with most of the things that Spitzer did, might feel very supportive of the litigation agenda of some other state attorneys general in other states who are more politically to their liking. There is a risk, to be sure, with an activist attorney general of bypassing the legislature, of bypassing the people, you might say. But the legislature also has ways of reining in an attorney general in an extreme situation. One might also argue that in certain kinds, well, first of all, I think many people would dispute the premise that what attorneys general are doing is really legislating by litigating, but in some cases, I suppose they are. One could argue that some of the issues that they address through litigation that ordinarily would be addressed through legislation are perhaps better addressed in a courtroom according to rules of procedure and fairness before a judge who is a neutral decision maker, perhaps also a jury, rather than in a politically charged environment where people are going to be voting for or against something, not necessarily on the merits, but because of campaign contributions and because of the influence of special interest groups who don't, at least as yet in our system, wield nearly the same kind of influence in the courtroom as they do in the legislature. So I think it's sort of a mixed bag. Bob listed a number of cases that you've all read about over the years, and indeed they are controversial. And some of them would strike, I think, most people as reflecting the actions of an attorney general who is totally out of control, and others might think, well, that seems perfectly reasonable and appropriate. I mean, the biggest one, the one that sort of started the sort of steamroller of criticism against the institution of activist AGs, I suppose, was the big tobacco litigation. And the tobacco litigation is usually held up as a paradigm of what state attorneys general should not do, right, from a conservative perspective. What they did is they went out and they hired lots of outside law firms. The law firms engaged they entered contingent fee agreements